Hello. I would like to talk to you today about a case that I'm going to refer to as PEARCE, an HMRC, First Tier Tribunal decision, and the full name and citation will be in the description below. But it is a business property relief case in the slightly unusual context of a wild fishery business. This decision was released only recently in September 2024. Now, business property relief is an inheritance tax relief which can apply to property consisting of a business. The consequence of this relief, and presumably its aim, was to protect family-owned businesses. A business, as a result of this relief, can pass between generations without having to be sold to pay an inheritance tax bill. It also encourages entrepreneurship and investment in small and medium businesses. The relief, however, is not available where the business in question is an investment business. So the question before the tribunal in this appeal was whether a wild fishery business was mainly or wholly a investment business. So the legal test is found in sections 104 and 105 of the Inheritance Tax Act 1984. And as we've already touched on, it is essentially whether the business consists wholly or mainly of making or holding investments. If it does, then the relief is not available. So, in other words, in order to qualify for the relief, it can't be wholly or mainly making or holding investments. And this can be quite a difficult question that is well known to arise when talking about holiday lets or bed and breakfast accommodation. HMRC's view is that furnished holiday lets will in general not qualify for business property relief, and the justification for that approach is that the income derived from such businesses will largely consist of rent in return for the occupation of the property. However, it's accepted that in some cases other services are provided to such an extent that it takes the business across the line so that it's not mainly a business of making or holding investments. For example, it's generally accepted that a hotel would get across the line, or indeed trading as a shop from premises owned by the trader would not be holding an investment in the premises. It would cross that line, and there is a spectrum where you have on the one hand something like a property that you're investing in, and then on the other hand you have the shop example. So sometimes it can be quite difficult to assess where a business falls on that spectrum. Now, one of the leading cases on the subject is the Upper Tribunal decision of Pawson, which concerned a bungalow in Suffolk, and it was a holiday let. In this case, several activities were carried on, including taking steps to find occupants, collecting rent, carrying out repairs and improvements to the property, maintaining the garden and grounds, keeping it tidy. The Upper Tribunal held that this was not enough, and they said, in any normal property letting business, the provision of additional services or facilities of a non-investment nature will either be incidental to the business of holding the property as an investment, or at least will not predominate to such an extent that the business ceases to be mainly one of holding the property as an investment. This case of PEARCE is a little bit different. It doesn't concern a holiday let or accommodation, but a wild fishery, which amounted to essentially a river, the river banks, and an office from which the business was run. So the way it worked was that the fishery charged customers a fee for access to the river, and some customers paid as part of an annual membership to a club which entitled them to access on certain dates or certain times. Others purchased day permits, and I think also there were trips sold by third parties. So it was clearly a business, and this wasn't disputed by HMRC. The business, however, made a modest income. Between 2017 and 2020, the average net profit was around £2,500, although it did reach as high as £6,000 in 2020, which was the year of Mrs. Pearce's death. Mrs. Pearce did work long hours at the fishery. She cleaned the riverbank of vegetation so that the fishermen would have access to the river. She mowed the grass, she managed the trees and plants to provide the correct amount of shade over the river so that the fish would thrive. She cleared the river of debris. She maintained paths and bridges over the river. She managed the conditions of the river for optimal breeding and development of fish. She took bookings, greeted clients, generally dealt with clients, among other things. Now, HMRC argued that this business was the exploitation of land to produce income, which is an investment activity. The appellants argued that the wild fishery business cannot be compared with holiday letting cases, and that if one were to look at the circumstances in the round, the business was the provision of services and incidental facilities, which took the business out of the investment category. So the question here for the tribunal was whether the circumstances of the business were sufficient to take it over that line on the spectrum, so that it was not mainly a business of holding or making investments in the land. So what does the law say about this? Well, we've touched on the case of Pawson, the upper tribunal decision, but there is Court of Appeal Authority of George and HMRC. That case concerned a caravan site business which operated a residential caravan park, where caravan owners paid to station their caravans in the park on particular plots of land, and then they were connected to gas and electricity, which was sold by the business. There was also a site for caravan storage, which members paid for, as well as a club for residents, which had a bar. And it was accepted by the taxpayer that there was an investment element to the business. Granting rights to station mobile homes on plots of land is akin to an investment. But there were many non-investment activities, the supply of gas and electricity, running the site, maintenance, etc. HMRC argued that the activities of maintenance and management were incidental to the letting, and that the provision of gas and electricity were required under the terms of the agreement with the customers, and therefore didn't alter the nature of the business from one of holding investments. The commissioners, as this was a case that predated the tribunal, with which the Court of Appeal agreed, dismissed HMRC's arguments and found that the services element of the business predominated. And the court found as follows, and it was the judgment of Lord Justice Carnwath, and he said, "I agree in general that property management is part of the business of holding property as an investment. So in the case of buildings held for letting, management no doubt includes the activity of finding tenants and arranging leases or licenses, and that maintaining the property all fall within the category of investment. But he goes on to say, I would not accept that additional services also fall under that category. So, for example, where the landlord obtained extra profits by cleaning, providing lighting. This was back in 1930, this example of providing lighting and providing heating for a profit. So those additional services don't fall under the category of investment. And then Lord Justice Carnwath noted that he finds it difficult to see any reason why an active family business of this kind, so this caravan site, should be excluded from business property relief merely because a necessary component of its profit-making activity is the use of land. So with that in mind, what happened in this case of PEARCE? Well, the tribunal found that the business was mostly an investment activity. Judge McKeever held that the essence of the business was that clients paid a fee for permission to come onto the land to fish from an allocated part of the riverbank, and there were no other sources of income. The extensive time that was spent mowing the riverbanks, clearing the vegetation, and maintaining the river, according to the tribunal, were activities to maintain and enhance the investment in the land. The tribunal disagreed that the fees paid by members of the fishery were fees paid for the service of providing a maintained fishery, but that the activities were analogous to the maintenance and enhancement of holiday lets to attract customers. Now, cases of this nature are always difficult, and one can't help when one hears the tribunal's conclusion to recall those words of Lord Justice Carnwath, where he ponders why can't an active family business, or why should an active family business be excluded from the relief merely because a necessary component of its profit-making activity involves the use of land. And that's what occurred to me when I saw the tribunal's conclusion. Anyway, thank you very much for listening to my talk about this first-tier tribunal decision of PEARCE.